Okay, let's get into it. Today we're tackling the rulebook of a major global financial hub, the Abu Dhabi Global Market, or ADGM.
That's right. And we've got some pretty dense source material, an announcement on their latest digital asset rule updates, plus big chunks of the actual regulations.
It sounds heavy, but our mission today is to basically cut through all that legal speak. We want to pull out what really matters, especially how ADGM is handling new stuff like digital assets.
Exactly. And what it means for you if you're operating there, or maybe thinking about it, think of it as, a guide to the financial laws of the land in ADGM.
Yeah, a shortcut to understanding how this key financial center works. Because at its core, ADGM seems to be doing this balancing act,
Yeah.
trying to encourage innovation, right? Fintech, digital assets,
Yep.
but also making sure it's stable and trustworthy. These rules are how they plan to do it.
And every plan needs an architect. In ADGM, that's the Financial Services Regulatory Authority, the FSRA.
Okay, the FSRA. So what's their power? How do they actually shape things?
Well, the key thing from the sources is they don't just enforce rules, they make them. That's their fundamental power-making rules, issuing directions
Oh, okay.
to basically achieve the goals set out in the regulations. They have a huge amount of control.
And these rules cover what they call regulated activities. Sounds broad.
It really is. I mean, the list is extensive. If you're involved in finance and ADGM, chances are you're covered. It's everything from the traditional...
Mailing in investments, arranging deals.
Exactly. Advising, insurance, taking deposits, custody, money services,
Mm-hmm.
but also operating trading platforms, MTFs, OTFs.
Right.
Plus managing assets, collective investments, even private financing platforms, and providing related third-party services. It's comprehensive.
So you can't just set up shop and start doing that stuff,
No, definitely not. You need permission, a financial services permission from the FSRA.
which involves an application.
Yep, typically for companies or partnerships.
Yeah.
And the FSRA can dig pretty deep, ask for more info during that process.
Okay, so you get the permission. Are you all set then?
Not quite.
Hmm.
That's really just the beginning. The FSRA keeps an eye on things. They can actually change your permissions later.
Oh, really?
Yeah, they can impose specific requirements too, like telling you how much capital to hold or restricting how you use certain assets. They could even force assets to be transferred to a trustee in some cases.
And if things go wrong, they can pull the plug.
They can. They have the power to cancel permissions under certain circumstances.
And the word for breaking these rules is...
Contravention. You'll see that term pop up a lot in the regulations. It's crucial because a contravention is what triggers all the enforcement actions we'll probably get into later.
Okay, contravention. Got it. Now, this is where it gets really interesting, especially looking towards the future. One of our sources dives into recent updates specifically about digital assets.
Yes, and this is key. ADGM isn't creating a totally separate sandbox for virtual assets. They're actively weaving them into their main regulatory structure.
So, bringing them into the fold rather than treating them as something completely alien.
Precisely. The update talks about amendments to their guidance on regulating virtual asset activities. It's about making things clear.
Clearer in what way?
Well, it seems they've put measures in place, and now they're giving more detailed guidance to firms dealing in VAs. A big part of this is helping firms figure out how to apply the criteria for what counts as an accepted virtual asset, or AVA.
AVA.
It gives firms a better roadmap for compliance in this space.
And there's that quote from Emmanuel Givanakis, the FSRA CEO. He called these changes a significant milestone.
Yeah, that quote really sums up their goals. He said, enhances the framework, provides regulatory certainty,
Addresses evolving risks.
and positions ADGM as a premier jurisdiction for responsible innovation. It's about being predictable, but also staying ahead of potential problems in the crypto world.
So how exactly are things like VAs and these fiat reference tokens, FRTs, like stable coins, how are they actually built into the rules?
Well, they're treated very much like other financial products in many ways.
Right.
For instance, the FSRA explicitly gets the power to set the criteria for what makes a VA an AVA.
Just like they do for other assets.
Exactly. And importantly, the FSRA can issue a direction, basically, in order to stop the issue, sale, transfer, or even holding of a specific VA or FRT if it violates the rules or if it's just deemed necessary for ADGM's interests.
So they can step in and halt activity around a specific token if needed.
Yes, they have that direct power.
And are VA activities themselves listed as regulated activities?
They are. The sources clearly show specific VA and FRT activities written into the definitions. Things like arranging deals in VAs, running an MTF that trades AVAs, providing certain services related to VAs, issuing an FRT, or handling payments with FRTs.
So if you're doing that, you probably need that FSRA license.
Very likely, yes.
Okay, this brings us to a really core concept, market integrity. Are the rules about fair markets applied to virtual assets too?
Absolutely. This is critical. The rules against market abuse, things like creating false impressions, manipulating prices, using dodgy schemes,
Right.
explicitly apply to financial instruments, accepted virtual assets, or accepted spot commodities. VAs are right there alongside everything else.
So manipulating the price of an accepted virtual asset on an ADGM platform is a definite no-no.
Correct. There's a clear prohibition on market abuse. And they even have a code of market conduct to give guidance on where the lines are drawn. Plus, there's a specific offense for creating misleading impressions about the market or price of AVAs if the intent is to trick people into investing.
Makes sense. And do the platforms trading these ABAs have to report what's happening?
Yes, they do. Trading venues, including MTFs trading accepted virtual assets, have to report orders and transactions to the FSRA. It's all about transparency and giving the regulator the data to stop potential abuse.
Okay, so market integrity is covered. What about protecting the users, the investors, and customers? What happens if you think the regulator got something wrong, or if a firm messes up?
Well, a key mechanism is the appeals panel. This body can review FSRA decisions.
Is it just a procedural review?
No, depending on the decision, it can be a full merits review, basically. They look at the whole case again. And the crucial part is the FSRA has to follow the appeals panel's decision. It's a real check on their power.
Okay, that's good to know. And what about punishing firms or people who break the rules? What teeth does the FSRA have?
They have a toolkit of disciplinary measures. They could issue a public telling-off, which they call censure, publish statements naming offenders, slap on hefty fines.
Financial penalties?
Oh, yes. And they can suspend or restrict activities or even disqualify individuals or completely cancel a firm's license.
Can they take things to court as well?
They can. The FSRA, and sometimes people who've been harmed, can go to court to get orders to stop the bad behavior or make someone fix the damage.
Like freezing assets.
Exactly. They can seek restraining orders to freeze assets so they can't be hidden or spent.
And can people get their money back?
That's the aim of things like restitution orders, forcing someone to return money or property they got unfairly. There are also payment orders, where the court orders a payment to the FSRA, who then distributes it to those affected. The court can demand access to accounts to work out the right figures.
What if a firm messes up and you suffer a loss?
Yeah.
Can you sue them directly based on these regulations?
Yes, that seems to be covered by actionable contraventions. The rules say if someone intentionally, recklessly, or even negligently breaches certain duties or commits fraud, they're directly liable to compensate you for your loss.
So you could take them to court yourself.
That's what it applies, yes. Restore you to the position you were in before.
The FSRA sounds like it has pretty significant reach.
It does. They can even jump into other court proceedings if it helps their objectives, and in serious cases, ask the court to wind up a company if it's necessary for ADGM's overall stability. Now, maybe we can shift gears slightly to some of the operational rules for firms.
Sure. Like who needs to be approved?
Well, for what they call recognized bodies. Exchange is the key people running the show, the ones overseeing regulatory stuff, the key individuals. They need the FSRA's sign-off.
Okay. And I saw something about a clearing obligation for derivatives. Sounds a bit technical.
It is, but the idea is simple: reducing risk. For certain complex contracts, particularly over-the-counter derivatives, ADGM wants them cleared through a central counterparty.
Like a middleman to guarantee the trade.
Sort of, yeah. It reduces the risk if one side defaults. And it's not just financial firms. Even large non-financial companies that use these derivatives heavily might have to comply and notify the FSRA.
And there are rules about how they manage that risk day to day.
Definitely. Firms have to have solid risk management procedures. That includes valuing the contract's daily marking to market and exchanging collateral quickly to cover potential losses. And that collateral needs to be kept separate, segregated.
Right. We also saw mentions of collective investment funds.
Yep. ADGM regulates funds, mutual funds, hedge funds, that sort of thing. Different types like public, exempt, qualified investor funds. Rules about registration, the fund manager's role, the trustee's role. It even mentions limited liability for investors in investment trusts.
And making sure trades actually complete properly. Settlement.
Yes, settlement finality rules. These ensure that once a trade is settled through a recognized clearinghouse, it's final. Done deal. even if someone goes bust afterwards. It covers margin, collateral, and how it all works with insolvency law. The FSRA can even recognize clearinghouses outside ADGM.
Can the regulator actually stop trading in a specific instrument?
Yes, they can require an institution, an exchange, or a licensed firm to suspend or remove a financial instrument from trading
Why would they do that?
for investor protection or if there's a risk to market stability. And they have to make that decision public.
Okay. Now, all of this regulation relies heavily on information flowing correctly, right?
Absolutely. Information is key. Reporting entities, like listed companies, have to disclose price-sensitive information promptly, issue a market announcement, file a report with the FSRA, and if the company drags its feet, the FSRA can publish the info itself. Transparency.
And it's not just the companies themselves, auditors too.
Right. Auditors and actuaries have a duty to speak up. If they see something they reasonably think is relevant to the FSRA's job, they need to tell the regulator. It's an extra layer of checks.
What about confidentiality? The FSRA must get loads of sensitive info.
They do, and there are strict rules about confidential information. They can't just share it freely, but there are important exceptions for public functions. Meaning they can share information with other regulators, AML authorities, sanctions bodies, the ADGM company registrar, and so on. But only under specific conditions and with safeguards in place. It allows cooperation between authorities.
And if the FSRA suspects wrongdoing, how do they investigate?
Their investigations powers are pretty broad, assuming they have good reason. They can compel anyone, not just the target of the investigation, to come in for an interview.
Can tell them.
Yes. Require them to answer questions, produce documents, provide assistance. They can also enter business premises to inspect documents relevant to the investigation.
What if a company tries to block access, say, claiming a legal right over a document, a lien?
Doesn't work. The source material specifically says a lien doesn't prevent production if the FSRA requires it.
Are there any documents they can't demand?
Yes, protected items. This usually covers things like legally privileged communications advice from lawyers and some sensitive government or security-related information.
I also saw something interesting about involving other regulators in these investigations.
Yeah, that's quite significant. The FSRA can allow officials from non-ADGM regulators, so regulators from other countries, to attend and even participate in interviews during an ADGM investigation.
Really?
Yes, but only if the other regulator has confidentiality rules that are pretty much equivalent to ADGM's. It shows ADGM is positioning itself as part of that global regulatory network.
And it seems like you don't have to be the main person breaking the rule to get into trouble.
Exactly. That's the idea of being knowingly concerned. If you help someone break a rule, or encourage them, or enable it, knowing what's going on, you're treated as if you broke the rule yourself.
And just lying to the regulator.
That's a contravention too. Knowingly or recklessly giving false or misleading information when you're obliged to provide it is a serious offense.
The rules also mention something about agreements made improperly, like are they still valid?
That's an important protection. The sources talk about the enforceability of deals made with firms that aren't properly authorized, or deals resulting from unlawful communications promotions that break the rules.
So a dodgy deal might just collapse.
It might not be enforceable. You might be able to get your money or property back. It discourages unlicensed activity and misleading marketing.
Okay, so that's a lot of rules. Does absolutely everyone touching finance and ADGM fall under all of this?
Not quite. There's a defined scope, and importantly, there are exemptions. Not every single entity or activity needs the full FSRA license or has to follow every rule. There are exempt persons.
Like who?
The sources give examples like governments, central banks, international bodies. Also, temporarily, some firms already licensed by other regulators in the UAE might be considered transitional persons for their existing activities.
And some activities might just be excluded altogether?
Yes, definitely. There's a whole list of specific exclusions from what counts as a regulated activity. Things like certain actions by trustees just doing their normal duties, activities purely incidental to a non-financial business, some internal group activities, things done by insolvency practitioners. The list goes on. The point is, it's not a blanket net. The scope is defined.
What about that rule against financial promotions, the financial promotion restriction? Are there ways around that?
Well, not ways around it, but exemptions. The basic rule is you can't push financial products unless allowed to protect the public. But it doesn't apply to everything. Communications to other financial professionals or to certified high net worth or sophisticated investors, certain large companies. There are also narrow exemptions for journalists, provided they disclose interests, and even for very specific one-off, unsolicited real-time chats.
Okay, so we've been through a ton of regulatory detail. Why does this actually matter to you, the listener?
Well, simply put, if you're operating an ADGM, planning to investing through it, or even just using a service-based, like a digital asset platform, these rules are the foundation.
Yeah.
They dictate how businesses have to act and, crucially, how you're protected.
Right. It's about providing that regulatory certainty we mentioned, managing the evolving risks, especially with new tech, ensuring the markets are fair, and giving you ways to appeal or seek redress if things go wrong.
It's ADGM building its case as a top-tier financial hub, one where innovation is welcome, but within a robust framework designed to protect stability and investors.
So we've covered a lot of ground today. The FSRA's power, the wide range of regulated activities, how digital assets fit in, the rules on market abuse, investor protection, enforcement. It's clear ADGM is building a very detailed, very comprehensive system.
Okay, very deliberate.
And they're consciously bringing new areas like crypto into that established structure. The level of detail is meant to build confidence, encourage that responsible growth.
Definitely.
Which leaves us with a final thought for you to chew on. In a world where finance and tech are changing so incredibly fast, think AI, think DeFi, how effective can these kinds of detailed prescriptive rulebooks really be? Can they keep up? Can they anticipate the next big thing while still achieving their core goals of keeping markets fair and protecting people? What kind of balance does this ADGM approach strike, and what lessons might other places take from it?